National Budget Office said the United States is on track to add nearly $19 trillion to its national debt over the next decade. That's absolutely insane. But instead of trying to get our economy back to normal, the Biden administration has worsened the problem by issuing reams of arbitrary new federal regulations. Any Arkansas business that's managed to survive Bidenflation is now being buried under a pile of red tape, and it's time for us to fight back. During my inaugural address, I promised to stop the meddling hand of big government. And today I'm announcing that I've asked Attorney General Griffin to sue the EPA to get the over-regulating, micromanaging, bureaucratic tyrants in Washington off of Arkansans' backs. Our lawsuit is over the EPA's ozone rule. When the federal government released this new regulation in 2015, they were required to give states the ability to craft our own state-specific implementation plans. This allowed Arkansas to comply with federal rules while also addressing our own unique concerns. In 2019, Arkansas submitted our proposed guidelines to the EPA. We took into account all available data at the time to comply with federal regulations while still managing to foster a friendly business environment. Our rules would have reduced pollution without reducing jobs. What we saw is a perfect balance. However, the Biden administration has rejected Arkansas's plan, and they have used anecdotal evidence and crude, inaccurate analysis to claim that Arkansas is letting polluters off the hook, when in all reality, nothing could be further from the truth. What's more, they're refusing to let us revise our plan to meet their demands. Instead, they're mandating a one-size-fits-all regulation for Arkansas and 24 other states, trampling on federalism and crushing Arkansas business. Critical Arkansas industries, and more importantly, Arkansas workers and their families, stand to be affected by this out-of-control federal overreach. That includes our power plants, natural gas pipelines, cement producers, steel factories, and glass, paper, and chemical manufacturers. The Biden administration is not only threatening dozens of Arkansas businesses, it's threatening thousands of Arkansas jobs. The Oswald Generating Station we're at today is one of the facilities that will be seriously impacted by the EPA's decision, and possibly even shut down. This doesn't just threaten the Arkansans who work here, it actually threatens Central Arkansas's entire electrical grid. We're not going to take that laying down. We're not going to let the Biden administration abuse their regulatory powers. We won't let them punish pro-energy states. We're going to take them to court, and we're going to win. One of the reasons we're going to win is because we're on the right side of the issue. The other reason is because we have a bulldog of an Attorney General who's going to make sure of it. I'm excited that Tim Griffin is here today, our Attorney General, and with that, I'm going to turn it over to him to make a few remarks. Thank you very much. Attorney General.
Thank you, Governor. It's great working with Governor Sanders because we share the same view on job creation and pushing back on federal overreach. And so when I was discussing what was going on with the EPA, I had the same concerns that she did. But we, as you know, can't sue over disagreement with the Biden administration. That would make for a really busy office. We have to have a legal basis. And in this particular case, we are on strong footing. So let's be clear what this is about. The governor has talked about balancing a care for the environment, a stewardship of the environment, with the economy and growing the economy. Well, the Clean Air Act, under the Clean Air Act, we have to come up with this as the state implementation plan. Now, the theory was the EPA, at least initially, was not going to just tell everybody what to do. They were going to allow states to craft, to develop a plan that fits their state. That's what federalism is all about, the opposite of top-down. So that was the theory. So in 2019, this was submitted. It was supposed to be reviewed by November of 20. Well, here we are. They save it for the day before Valentine's Day. right? In February of 23, and the EPA says your state implementation plan is disapproved. It doesn't say, hey, we've got some issues with it, Governor. Can we work with you for a solution that's best for everybody? No, that's not what they did. They just said, done. We know we're late, but you're disapproved. Oh, and by the way, the goalposts had been moved. When you were tasked to do this initially, there was an analysis that was based on data, a standard based on data, that looked at the upper Midwest. And it was 2017 data. Well, now, after they've disapproved the state's plan, we find out they've moved the standard for the data. Now they're looking at the Dallas, Fort Worth, Houston metropolitan areas in more recent data. So they've moved the goalpost and given the state, given the governor, no opportunity to revise. And so, in this particular case, I believe what's going on is the federal government wants the federal implementation plan for everybody, and that, I believe, is why they didn't give us an opportunity to change. Now, we filed a petition for review under the Administrative Procedures Act. We'll be able to get you the petition later. It's really short. There's not a lot to it. Maybe they are used to states being unhappy and said, we're going to make this easy on you. So we filed in the 8th Circuit Court of Appeals with the governor's own administration, the Department of Energy and Environment, specifically the Division of Environmental Quality. And so we filed that today. We've not been assigned, as of pulling up here, a docket number. But we filed a challenge to this disapproval. And we believe that the Biden administration has acted beyond their authority in this particular case by moving the goalpost and basically abrogating the authority of the states by just saying, well, we know we're late. We know we moved the standard, the goalpost. We didn't like it, and by the way, we're not going to let you try to fix it. So we believe that we're on strong footing here. We believe we'll be successful. And as the governor said, what's at risk is the priority that she's placed on continuing to grow the economy. And I appreciate the governor allowing me to be here today. Thank you.
Take a couple questions if there are any. Yes, sir.
As I remember, the Arkansas SIP plan, when it was filed, the EPA said that Arkansas would have to lower its ozone emission standards. So what is the issue with Arkansas SIP plan?
Well, and Caleb Osborne is here as well. Caleb, if you don't mind jumping up here. One of the issues is that it's just a flat denial without any option for us to review and make changes. Mm-hmm. And so, Caleb, I don't know if you want to speak to any specifics, but that's one of the biggest problems is that there is just an absolute flat denial and no option for changes for us to fit into a new plan. And instead, trying to force that one-size-fits-all across the board on everybody. Caleb, I don't know if you want to jump in on.
No, thank you, Governor. Yeah, part of the challenge there is that you're looking at individual facilities, you're looking at controls that need to be put in place. With the change and with the denial of the SIP, it removes our ability to help identify those and where those controls are going to be put in place, and instead paves the way for a federal plan to come in, which is intended for a much broader application nationally. So it overlooks a lot of the details and unique aspects of our economy and what types of facilities we have that would be covered here.
Andrew?
I guess this kind of similar question. I guess what are the big differences between the federal plan and the state implementation plan in terms of what would facilities in the state have to do under the federal plan versus what they'd be able to do under the state plan?
The federal plan is going to be, well, we have a proposed plan that's not final. We understand that it should be finalized this spring. But it is more prescriptive in specific controls that we put in place. and it paints with a much broader brush of what the impacts would be. Our team can get you more information about that if you'd like, and kind of how those would apply. But in general, what happens is you get saddled with some controls that are going to be much more costly to implement, and we're not sure. And really, based on our modeling, what we've done, we don't think they're going to have the outcome towards compliance that is really intended by the rule.
Why this facility at risk?
This was one of the facilities that was identified as subject to, under the federal implementation plan. This was one of those. I don't have the specific data from the modeling, but it came up as one of those that would be impacted.
Is it because of fossil fuels or not having the right mix?
It has to do with, so the rules for ozone, primarily we're looking at NOx emissions, nitrous oxide emissions, and it has to do with what the data indicated of what the emissions were from the facility. And we can get you additional information about that. Go for it.
There were roughly, and Caleb, correct me if I'm wrong, but roughly 50 different businesses around the state that would be directly impacted, again, with the possibility of closure due to the federal plan versus the state plan.
Because they exceed the ozone emission standards.
Because they don't meet their impact, yeah, on other states. They're trying to basically blame us for the problems caused by other people. Take one last question. Anybody's got one?
I guess what are the prospects of this in the 8th Circuit, and how many other state challenges are there right now?
I know there's at least 2 other states already, not in the 8th Circuit, that have made filings, and we feel pretty good about where we are, though, based on the merits of the case. Thanks so much, guys.